Welcome to the 55th episode of the SCC Online Weekly Rewind. I am Prachi Bhardwaj and I have got for you some interesting legal updates and also the winners of this week's SCC Online quiz. This week's top story is from Delhi High Court, where in a claim of maternity benefit by a contractual employee, the Division Bench of Delhi High Court has expressed that the Maternity Benefit Act 1961 is a social legislation that should be worked in a manner that progresses not only the best interest of the woman employee but also of the child, both at the prenatal and the postnatal stage. Further, the bench stated that limiting factors for the grant of maternity benefits are: first, the woman employee should have worked in an establishment of her employer for a minimum period of 80 days in a 12-month immediately preceding the date of her expected delivery. Second, the maximum period for which she can avail maternity leave benefit cannot exceed 26 weeks, of which not more than 8 weeks shall precede the date of her expected delivery. Adding to the above, it was also stated that for a woman employee who has 2 or more surviving children, although the maximum period of which she can claim maternity benefit is 12 weeks, the period preceding the date of expected delivery cannot be more than 6 weeks. The Supreme Court has issued notice to the Bar Council of India to respond to suggestions made before the court at the earliest with regard to introducing changes in bar examination after an appeal was filed by the BCI against the Gujarat High Court order, wherein the High Court had read down rules number 1 and 2 respectively of the Bar Council of Gujarat enrollment rules under section 28(2)(d) read with section 24(1)(e) of the Advocates Act, so as to read that a person may be either in full or part-time service or employment or is engaged in any trade, business or profession who is otherwise qualified to be admitted as an advocate shall be admitted as an advocate, however the enrollment certificate of such a person shall be withheld by the Bar Council and shall lie in the deposit with the Council until the concerned person makes a declaration that the circumstances mentioned in Rule 2 has ceased to exist and that he or she has started his or her practice. After a number of suggestions were made before the court, the BCI was asked to consider them at the earliest. You can read all the suggestions and the detailed report on the case on the SCC online blog. In a case where a development plan was finalized in the year 2002, but the same was never implemented, nor any action was taken for acquisition of the land under the Land Acquisition Act 1894, the Supreme Court has held that the Bombay High Court's direction to acquire land within a period of 1 year, 20 years after the development plan was finalized, was in contravention of the timeline fixed under the Maharashtra Regional and Town Planning Act 1966. The court observed that such timeline is sacrosanct and has to be adhered to by the state or by the authorities under the state, and that the landowner cannot be deprived of the use of the land for years together. Once an embargo has been put on the landowner not to use the land in a particular manner, the said restriction cannot be kept open-ended for an indefinite period. In a petition filed by the child of a deceased government servant's second wife, the Chhattisgarh High Court has held that an illegitimate son would be entitled to consideration on compassionate ground and cannot be denied consideration on the ground that he is the illegitimate son of the deceased government servant. while stating that in an Indian society, normally expenses are required to be incurred for pre-marriage and also at the time of marriage. The Division Bench of Chhattisgarh High Court has held that unmarried daughters have a right to claim expenses of marriage from their parents under the Hindu Adoptions and Maintenance Act 1956. The court also expressed that a right is created to claim the expenses incident to marriage, and the courts also cannot be in denial mode when such rights are claimed by unmarried daughters, while expressing that it is the duty of the welfare government to protect not only the citizens but to continue with all the government work as expected. The Division Bench of Kerala High Court directed that the government servants should be prevented from engaging in strike. The bench also made an observation that government servants should not engage themselves in any concerted or organized slowing down or attempt at slowing down government work, or in any act which has the tendency to impede the reasonably efficient and speedy transaction of government work. Concerted or organized refusal on the part of government servants to receive their pay will entail severe disciplinary action. The Division Bench of Madras High Court has expressed that the government advocate, being the representative of the government, has to act in an honest manner. If he or she goes around with the intention to make money at the cost of justice, only chaos will prevail. The High Court also remarked that every advocate is a court officer and part and parcel of the justice delivery system. The public reposes great faith in the judiciary, but the judges have to rely on their pillars, the advocates. While addressing the question that if the victim's underwear was not taken down and the man merely rubbed himself on the victim's crotch while she still wore her underpants, would that amount to commission of rape? The Meghalaya High Court held that by virtue of Section 375C of the Penal Code, when a person manipulates any part of the body of a woman so as to cause penetration into the vagina or urethra, the act would amount to rape. In a case relating to arbitration agreement, the Delhi High Court has held that mere use of the word arbitration in the heading of an agreement between the parties would not lead to the inference that there exists an agreement between the parties seeking resolution of disputes through arbitration. On 30th March, the central government has passed the Finance Act 2022 for the financial year 22-23. This act will be effective from 1st of April 2022. It introduces virtual digital asset as taxable asset under Income Tax Act 1961, and from 1st of April 2023 onwards, VDA will be taxed at the rate of 30%. Such cryptocurrencies will be identified as virtual assets. Income earned out of these assets will be of taxable nature and charged at the rate of 30%. Read the full report on the SCC online blog. The President has notified Union Territory of Chandigarh employees Conditions of Service Rules 2022 regulating the conditions of service of persons appointed to the services and posts under the administrative control of the Administrator of the Union Territory of Chandigarh. The rules provide that the central service rules to apply in the Chandigarh. They shall come into force on the 1st of April 2022. On March 28, the Ministry of Finance has issued Faceless Jurisdiction of Income Tax Authority Scheme 2022, which will come in force with immediate effect. By this scheme and Section 130 of Income Tax Act 1961, the central government determines the jurisdiction of income tax authorities in faceless or e-assessment of taxes. On 21st of March, the Food, Civil Supplies and Consumer Affairs Department of Gujarat has notified the Gujarat Consumer Protection Mediation Rules 2022. These rules provide that the mediation cell will have panel of mediators elected by commission to help parties to reach a mutually acceptable resolution of dispute. Now on to the most awaited segment of the episode. This week, we asked you to name the subtopics that are included under the intellectual property as indexed in the curated topics on the SCC online web edition. The correct answer is 5 subtopics, that is copyright, patent, trademark, design and geographical indication. And the winners of this week's quiz are Albab Alam and Yash Bhatt. Congratulations to the winners. That's all from this week. We'll be back with more legal updates next week. Till then, stay tuned to the SCC online blog for the best analytical legal news.